A recent state Supreme Court decision ruled that journalists can qualify as researchers and thus be eligible to obtain protective service records from the Arizona Department of Economic Security. Joining us now to talk about this is Greg Leslie of the First Amendment Clinic, which represented our other guest, journalist Amy Silverman, who is investigating the agency's responses to abuse allegations. It's good to have you both here. Thank you so much for joining us. I want to start with you. The First Amendment Clinic, let's just get, what is that?
It's a clinic at a law school. It's a movement in law schools to make law school more practical, to teach students how to actually litigate cases. And so clinic will take on a specific topic, and ours is the First Amendment.
Yes.
And so I teach kids in law school how to actually litigate these cases. And two of them got to argue before the Supreme Court. So
and apparently did a pretty good job of it there. Amy, this is your case. What exactly were you researching, and what kind of walls were you hitting?
So in 2020, I did a year-long project with ProPublica and the Arizona Daily Star designed to investigate services for people with intellectual and developmental disabilities and what their lives are like in the community, because we've changed the laws a lot over the years and gone from institutions to the community and smaller group home settings, which is great until you start to drill down and see that people's lives aren't necessarily much better. And a lot of the records that are kept, a lot of the information is very hard to get to. It's very hard to source this, as you might imagine. People live in isolation, which is hard. And so Greg worked with me on a couple different public records requests, including this one, which was for Adult Protective Services investigative background materials, because their substantiation rate is so incredibly low. When you file a complaint with APS, you maybe don't hear back at all, and ultimately it's maybe 3% out of thousands and thousands end up being substantiated. So we really don't know what's going on with the most vulnerable people.
And so to get those records, DES basically said, no, we can't do this. There's confidentiality issue here. What was DES saying, and how far were they willing to go on this?
Well, you know, it's a classic problem with public records laws. There's a commitment to openness, but there's also a guarantee of privacy. And obviously, there are legitimate privacy interests when this kind of information is at stake. So there's a state law here saying this shall be confidential. So it's an exemption from the public records law. And then that makes exceptions to its own secrecy pledge and says, unless you're doing bona fide research. And so the agency, we said, a journalist is doing bona fide research. They said, no, that's only research that helps us run the agency. And so they gave us nothing. They were not willing to give anything. And so that's what the fight was that we took to the Supreme Court. It's a journalist doing bona fide research.
I was going to say, most journalists who do investigative work, especially, that is research.
I did have to ask, what have I been doing the last 30 plus years?
Yes. Yeah. So how did you respond when you got that kind of response from DES?
Oh, well, we weren't all that surprised, because this certainly isn't the first time that that's been used as an explanation. But I always, in my initial request, say, you know, I expect that this material will be redacted. If it's going to be onerous to do the redactions, I'm happy to talk to you about doing just a sample size, tweak my request to make it work for both sides. And that went ignored.
Yeah, and so here comes the case. Here comes the First Amendment Clinic. What was the argument? How was it presented?
Well, we said, look, there's a statute that says, yes, there are privacy interests that have to be protected, but bona fide research is exempt from that, and that has to mean something. And because it incorporates right within that definition that there will be redactions for privacy reasons, it should mean that anything done in the public interest qualifies as bona fide research. So, you know, they're trying to make it exempt so that lawyers who are litigating cases don't go there as a first way of getting information, and that people don't just, for commercial reasons, gather all this information. But if you're doing something in the public interest, I did argue that you fit nicely within that exemption.
Well, and again, doing investigation as a journalist, you're not doing it for giggles here. You're doing it for the public interest every time, aren't you?
I mean, well, we want to reveal the truth.
Right. So this particular decision, How does it, not just on this case, but impact you as a journalist overall, impact all journalists doing work, research work?
It is narrower than I had originally thought. So I'm going to let Greg explain that because it just applies to DES, correct?
This one
But can
statute.
it have broader implications?
If there were a similar statute, I think the wording of the Supreme Court could be used in other situations. But in this case, very specifically, this one statute is about DES records.
Okay, so narrow here, but a possibility for a more broader rule.
Right, because the Supreme Court did something else interesting. They said if you do that, if you say that it can only be for requests that actually help the agency and only for people who are doing that, then you've got some First Amendment concerns to worry about. So the fact that, that's the dream of public records litigators, is to say, this isn't just about a statute that gives access, this is about a First Amendment right. And so they opened up that door, and I think in a very good way that will let people in the future say, no, there's a First Amendment interest at stake.
And now this goes back to trial court, true?
Right, yes.
And the process there is?
We've just got to argue about how they can implement this and discuss how easy it will be and what range of records they can work on, things like that.
And while all this is going on, your investigation goes where?
Well, I've continued this work because that's my beat. And actually, I was able to do a project for KJZZ where I work now using some other records that Greg helped me get. So this won't go, unreported once we get the information, but we are already 4 years in. And so then you have concerns about how old the information is, what's happened in the last 4 years, and how much longer is it going to go on? So while, I'm so incredibly grateful to Greg and the First Amendment Clinic, it was a good lesson for me in the challenges of litigating something like this.
Yeah, and the possibility of floodgates opening once this is all said and done. True?
You mean a lot of information to go
Yes.
through? Well, that's a dream.
Well, it's a dream.
Kind of a sick dream, but no.
It's a dream, yeah.
Yeah,
At least-
it would be quite a bit of information. I'm not expecting. I think we would negotiate a more manageable amount for the agency. I don't want to keep them from being able to do their jobs.
Yeah, makes sense to you?
Oh, yeah. Yeah, I think the negotiation is going to be important, but we won the big principle. So we have our right to go to court and demand some access now.
Okay, and the big principle, again, narrow here, but the possibility of expanding at a future date.
Right, or that anytime you say certain records must be sealed, as long as must be kept confidential, as long as you accommodate the fact that there are ways to protect privacy interests,
Yes.
there should be greater public access. That's
All right.
really what this case will help us argue in the future.
Well, Greg Gletzley and Amy Silverman, great job reporting, great job litigating, and congratulations to you both. Thanks for sharing your story.
Thanks for having us.